Howdy, folks. Minnesota Press here, coming at you live from Brainerd, Minnesota, Crowing Soil. The date is 8/12/2026. The time is 1:05 p.m. I came here to talk to you about the Sixth Amendment of the U.S. Constitution, which states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have previously ascertained by law, which they have not, and to be informed of the nature and cause of the accusation, which they have not, to be confronted with the witnesses against them, which they have not, to have compulsory process for obtaining witnesses in his favor, which they have not, and to have the assistance of counsel for his defense, which they have not. So the state, aka the county attorney, Kelsey Ann Hops, has deprived me of these Sixth Amendment rights, and if the court is a constitutional court and the honorable judge is actually honorable and honors his oath, he will not force a plea when I do not understand the cause of the accusation. In order to support the Sixth Amendment, speedy, they don't know what speedy is. I hear you there, Zephiel. In order to support the Sixth Amendment, Minnesota has enacted a rule of criminal procedure. It is Rule 4, Subdivision 5, Item number 3, a complaint, tab, charge, or citation. Now, you folks can go and follow along with this case. Here it is right here. It is case number 18CR262036. Based on that ICR number right there, 26001383. This is an obstruction charge stemming from June 7th, 2026. So you can go ahead and follow along, and you will see that in the case file there is a citation, which we cannot see, but I have here in the file. A citation summary, which you can see, lists me as a driver when I'm simply recording the interaction with public officials on a public sidewalk, not driving at all. So you can see the citation summary that lists me as a driver, and that's it. There is no cause of action stated in the court file, and the rules of criminal procedure say that in a misdemeanor case, if the judge orders or if requested by the person charged or defense counsel, a complaint must be filed. In a misdemeanor case, the complaint must be filed within 48 hours after demand if the defendant is in custody. Well, I'm not currently in custody, but I was. Or within 30 days of the demand if the defendant is not in custody, which I am not. So it looks like they have 30 days from today once I request this formal complaint to get it to me. If no complaint is filed within the time required by the rule, the defendant must be discharged. A complaint is valid when it complies with the requirements of Rule 2 and the judge has determined from the complaint and any supporting documents or supplementally sworn testimony that probable cause exists to believe that an offense has been committed and that the defendant committed it. They're going to have a hard time with that one. I really think you should have a lawyer represent any events not to do any legal lifting. The court is set up to punish people representing themselves. I agree with that, Zephiel, as you can see by my First Amendment case against Mr. Josh Heinzman. I'm well aware of that. I just can't afford an attorney, and I don't trust public defenders who are paid by the same state that this prosecutor and these judges are. So I'm not saying the judge in this case right now is dishonorable. I pray he is not. It would be the first judge I've seen in a while that's honorable, that honors their oath of office. But The complaint's valid when it complies with Rule 2, and the judge has determined from the complaint, if it's true, that any supporting documents or supplemental sworn testimony that probable cause exists to believe that an offense has been committed and the defendant committed it. So they're going to have a hard time doing that because there is nothing in the video that shows that probable cause to exist to believe an offense has been committed. Upon the filing of a valid complaint in a misdemeanor case and the filing of a valid complaint, the defendant must be arraigned. And when a charge has been dismissed for failure to file a valid complaint and the prosecutor later files a valid complaint, a warrant must not be issued on that complaint unless a summons has been issued first, and either could not be served or if served, the defendant failed to appear in response. Well, none of that's the case. So we're going to go see if this Judge Helverson, honors his oath to uphold the Sixth Amendment of the Constitution of the United States, which is supported by Minnesota Rules of Criminal Procedure, Rule 4, Subdivision 5, Item 3. That's what we're doing here today. And like I said, we're involved in case number 18CR262036, stemming from ICR number 26001383, which any of you can go and get the public data for that incident. You go to the Crosby City, ask for the responsible authority, and request the incident data under Minnesota Statute 13.82 Subdivision 3, I believe is what it is. Incident data, you can get all of the incident data that's associated with that incident. And you can follow along with the case on MCRO, which is Minnesota Court Records Online.org. My arraignment is scheduled, that they won't be able to arraign me in, is scheduled for 1:30. Time is 1:12. I better wrap up this live and get in there. Until next time, Minnesota Press out.